Good evening. This side Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multinational headquartered group based out Singapore. We are a multi-asset and multinational hedge fund. But having said that, we are proprietary in nature. By proprietary, I mean to say no third party. I repeat, no third party can invest capital in our fund. Like I told you that the legal desk, I repeat, the legal desk of Treasury Consulting Group is in action. And this is a very delicate video. I repeat, a very delicate video which I am making as far as one of the highly debatable, I repeat, highly debatable topic is concerned. And the name of that topic is known as anti-suit injunction. I repeat, anti-suit injunction. Please understand that the relevance of anti-suit injunction is very rare, which means out of probably 100,000 cases, you have one or two cases where anti-suit injunction came into the picture. In fact, I would say as far as the anti-suit injunctions are concerned, we have other variants also, which is anti-suit injunction. One is anti-enforcement injunction. One is anti-arbitral injunction. One is anti-arbitral injunction. And trust that when it comes to anti-enforcement injunction and when it comes to anti-suit injunction, the success factor is almost 0.01%. So what I mean to say that you are drafting your petition, the papers which you are submitting in the court, the deliberations which you are submitting before the honorable judge, that has to be immaculate. Because if you expecting to have an anti-suit adjustment and your petition, your deliberation is ordinary, then forget. It's a sheer waste of time because the success is 0.01%. But before I move to anti-suit injunction, now in the later stages, I will not refer this completely. I refer this as ASI, which means anti-suit injunction. You know, guys, you first need to understand what is an injunction because that's very important. Injunction is nothing but a kind of stay, I would say, which any honorable court, it could be a trial court, it could be a session court, it could be a first appellate court, it might be a high court, it might be a Supreme Court, or it might be an appellate tribunal, or it might be arbitral tribunal also. So injunction is nothing but a kind of stay these respective institution put as far as a legal case is concerned. Now that injunction might be granted to the plaintiff. In legal language, the plaintiff means the person who brings the case, or it might be granted to a defendant. That is completely dependent on who is pushing the honorable court or probably appellate tribunal or maybe arbitral tribunal for any injunction with valid reasons. Please take a note of that. Majority of the people do not understand that injunctions are very, very common as far as the civil case is concerned, as far as the criminal case is concerned. Unfortunately, there is a mindset which is created in the legal fraternity and in the public is that injunctions are only applicable in the civil suit. No, injunctions can also applicable in the criminal suit also. But having said that, we really need to understand that when you are moving towards injunction, you should have a very valid point. And there is another wrong mindset which is created in the system that injunction is all about first mover advantage. In English, the meaning of first mover advantage is whosoever move first would get an injunction. No. When you apply for injunction, please take a note of that. Whether this is a trial court, whether this is a session court, whether it's a first appellate court, whether this is high court or probably the Supreme Court or maybe the special court of respective countries, you need to file an application for injunction, and in this application you have to mention very clearly, I say very clearly, rather explicitly, that why are you looking for injunction. So if plaintiff, which means a person who bringing the case, is filing an injunction, it means he is informing the defendant that you please be ready, I am going ahead for injunction. Vice versa, if the defendant is asking for an injunction, he is informing the plaintiff that you please be ready, I am going ahead for injunction. So please do take a note of that. These two negative mindsets, that injunction is always in the civil cases, it is not in the criminal cases, that is absolutely wrong. Second, injunction is always awarded as a first mover advantage, that is also not correct. Now, there is a concept called anti-suit injunction. I repeat, ASI. From the last several days, I am doing a thorough reading of a case law in India. And as the time would progress, I would be bringing more case laws before you on our YouTube channel. This case law pertains to the Honorable Delhi High Court, who grants anti-suit injunction, and this pertains to a plaintiff, Interdigital Technology Corporation, and Xiaomi Corporation, who is defendant. So I took the printout of two separate copies. This is the copy number one. I took the printout, and this copy, and this is the second copy of that. I took the printout. Having said that, the facts which both the copies are saying having few interpretation issue, but I will discuss this later. Interpretation issue from the angle of, I would say the way they presented. But one thing which I always agree, one thing which I'm always thankful to the Honorable Delhi High Court, that Honorable Court opened the door of anti-suit injunction. And that is really a very, very thankful, and I thank you to the Delhi High Court for that. Because now with this judgment, you can easily claim anti-suit injunction. Please note my word carefully. Easily means you should have a very valid reason. You should have an explicit reason. You should have something which can substantiate your facts in a very deliberate manner. Your petition should be made according to the facts and figures. So please understand my words very carefully. In the part 3, I would be deliberating more what is anti-suit. Please note that the world is globalized. By globalized, I mean that, you know, one foreign company is interacting with Indian company, one Indian company interacting with a foreign company. The world is globalized. India is a brand now, and in fact big banks, financial institutions, advertisement agencies, cricketing bodies, and everyone wanted to work with India. So common sense is that where there is a business, there is a dispute. You know, business and dispute cannot be separated. History is a witness of that. Businesses always led to dispute. Sometimes this dispute is out of ignorance, which means that the contracts which were drafted at the time of the initiation of the business, they were not drafted in the right way. You know, even several books were written that when you are signing a contract, when you are binding a contract, you should be very thoughtful. You should cover each and everything. You should even cover the thing whereby the probability of occurrence is 0.01%. But unfortunately, the reality we all understand not to mention. Sometimes the dispute happens because of unlawful or implicit, desire of one party. When one party wanted to bypass the contract, when one party is getting greedy, and one party feels that, they can make more money if they bypass the contract, and here comes the dispute. But in a cross border dispute, there is one advantage which both the parties are having. And this advantage is their local court of law. So it means that if there is a company who from England, and this company is having a court of law which is the English, and we have a company in India, when this company having court of law in India, then both prefer to litigate any dispute in their respective countries. But unfortunately, what I noticed, is that if you are signing a contract, and probably it is $1 million contract, $2 million of contract, $3 million of contract, 4 million of contract, or maybe whatever amount, please remember that you supposed to mention the dispute, the governing law, the body who would be litigating this, and more importantly, whether the law, whether the contract, in itself is giving a permission to file anti-suit injunction or not. So anti-suit injunction in this case, which I am studying, which is Interdigital Technology, who is a plaintiff, and Xiaomi Corporation, who is a defendant. In this case, Xiaomi Corporation went to China, which is the Wuhan court, the local court, and they took some order which is against the, Interdigital Corporation. But before this order, if I go with the facts which are presented before me, before this order, Interdigital already filed a civil suit with Honorable Delhi High Court, and this was sub judice. The notion was that, according to Interdigital, the plaintiff was that the purpose, or basically the impunged order, in law, impunged order means that, something which is challenged, something which is not free, something which is currently challenged. This is called impunged order. Interdigital Technology was having of opinion that there is no point of having Vaughan into the picture when this is a case of patent which should be litigated in the territorial of India. although there are variety of definitions of anti-suit injunction, but one definition is when either party, whether that party is plaintiff or whether this party is defendant, is getting an order which is from a foreign court, or probably an institution which is outside the institution wherein the case is already sub judice, and this order is hampering, I would say, the litigation process which is already initiated in some country. Rather, this order is trying to obstruct the order which is or a litigation process which already began. There is a concept called principle of comity. I would repeat, principle of comity in law. And according to principle of comity, that the foreign jurisdictions, any jurisdiction, when passing anti-suit adjustment, should be very careful, which means that if the foreign jurisdictions are not giving respect to other foreign jurisdiction, it means that the other foreign jurisdiction will also not give respect to this foreign jurisdiction. But having said that, principle of comity is not barring you not to issue anti-suit injunction. It just means to say that ASI should not be a weapon which can fire like a drop of a hat. The courts of any jurisdiction should be very careful while firing this weapon, because once you issue anti-suit injunction, or probably anti-suit injunction, or maybe anti-enforcement injunction, in this case there is a case of law. I don't want it to use, but I read few books, and in these books I noticed that few countries in the world, especially the western side, I would say, they love issuing anti-suit injunction. Guys, please do remember that anti-suit injunction look very fancy on paper, but like I said, it completely dependent on how how explicitly you have made your petition, how you are expressing your case, what is the reason, why are you going for anti-suit injunction, why are you not allowing either party, if you are plaintiff then defendant, if you're defendant then plaintiff, to take this court outside the territory where it is already litigated. What are your rationals behind that? And more importantly, the contract which you signed for anything between both of you, whether this contract is permitting you to have anti-suit injunction or not. Unfortunately, the litigation is having very limited material on anti-suit injunction, because these are very rare thing, like I clearly said in the very inception of the video. But having said that, if the lawyer is strong, if the lawyer is having IQ, if he is able to present in a very relevant way, if the petition is handled in an appropriate way, in this eventuality, either injunction or anti-suit injunction, both is possible. Guys, we'll keep you posted about the various issues in the law, but let me assure you, law is a very interesting topic. It has several interpretation issues. The point is very clear how articulately, how explicitly you are putting your point. This is Rahul Magan.